Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Kaler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com. FCPA Flash is sponsored by Kroll. Kroll is trusted by companies and compliance officers worldwide to help prevent, detect, and remediate FCPA challenges with scalable end-to-end compliance solutions. From high-volume third-party screening and automated monitoring, to risk-based due diligence, to complex investigations and monitorships. With leading experts, global resources, and advanced technology, Kroll is uniquely positioned to meet all your FCPA needs.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Kaler, and I invite you to my next FCPA Institute in Phoenix, Arizona on January 11th through the 12th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash. This is Professor Mike Kaler, and in this episode I'm pleased to be joined by Robert Luskin, a well-known and respected lawyer at Paul Hastings. Luskin devotes much of his practice to the particular challenges posed by the representation of foreign companies and financial institutions in multi-jurisdictional, cross-border criminal investigations. Indeed, Mr. Luskin has represented French companies, Technip, Total, as well as Netherlands-based SBM Offshore in FCPA enforcement actions. Thanks for joining me today in the FCPA Flash podcast.
Thanks very much. I'm delighted to be here.
Now, you recently did a Q&A with the Corporate Crime Reporter in which you stated that foreign corporations and FCPA inquiries have had some real concerns about whether U.S. lawyers are really defense lawyers or, as you said, former prosecutors in a better suit, and that some FCPA practitioners are not willing to be adverse to the DOJ. Can you elaborate on these points?
Well, I sure can. I mean, I think that there is a great deal of suspicion in Western Europe about the role of U.S. lawyers, and in particular, whether U.S. lawyers are sufficiently vigorous as advocates for their clients. Part of that concern, I think, reflects an insufficient understanding of the role of cooperation in the U.S. process. But I think the greater part of the problem is that the concern is well-grounded, and that U.S. practitioners tend to go into autopilot cooperation mode without a full understanding of whether or not that particular course is in their client's interests, and at the same time, whether or not that's the course that the client really elects. So it's like having an ice cream shop that only serves chocolate.
Now, I've called this dynamic sort of the rollover and play dead and cooperate mindset that is often present in FCPA practitioners. Do you think this is unique to the FCPA or a much broader problem when it comes to other corporate criminal investigations by the DOJ and or the SEC for that matter?
Well, I think particularly given the number and size of FCPA matters that we see, which I think is probably in its own right the most salient aspect of corporate criminal enforcement that's going on, you see it most visibly here. But I think it may also be a function of the fact that this is a practice area that is heavily populated by folks who came out of the fraud section, and I think in all cases haven't left all of their prosecutorial experience behind. I mean, it's an incredibly useful perspective and experience, but the fact is that lawyers need to understand that they are advocates for their clients, and that it is possible, honestly, to look across the table at the government and say no. I mean, that's an outrageous demand. That's an unacceptable position. You really need to rethink your approach instead of simply saying, okay, we'll get back to you and do that next week.
Now, related to this this dynamic, of course, is the FCPA turns 40 very soon. And in the 40 years of this statute, the DOJ has been put to its ultimate burden of proof just twice by business organizations, and in both of those cases, it actually prevailed. And in nearly 40 years, the SEC, to my knowledge, has never been put to its ultimate burden of proof by an issuer. Why not?
Well, I think that for public corporations, they are simply too risk-averse to test the outcome. And I think the other consideration is that with the sentencing guidelines, the penalties are honestly so extreme that it's rolling the dice in a way that a public corporation can't accept or embrace. I mean, when you start looking at numbers that are into the multiple billions of dollars as a result after verdict, and when you are, conversely in the context of settlement, looking at enormous discounts over the low end of the guideline range, or genuine engagement on ability to pay, it becomes very difficult for a client to say, we're going to test the government. I can think really of my corporate clients, and this is outside the FCPA area. I can think of only one publicly traded company that in the last 10 years has said to me, we didn't do it, we're not guilty, we're not going to settle on something that we didn't do. Do whatever you can to get the right result, but understand that compromise is not part of our position. And ultimately, we got a declination in that matter. But that representation completely stands out in my experience.
So the dynamics you portray are obviously they're there, but in a legal system based upon the rule of law, do you view this to be a problem in terms of how the law should advance? I mean, let's face it, there are some instances of corporate FCPA scrutiny where it's quite clear the FCPA was violated, and why would that particular company put the DOJ or the SEC to its burden of proof? That'd be foolish. But in many instances, I think there is an open question, not whether the conduct fits the DOJ and SEC's enforcement theories. In many cases, the answer to that is yes. But in many situations, there's an open question as to whether the conduct violates the FCPA as intended by Congress, or as a court would interpret that. And do you view that as a problem for the advancement or progression of a law?
Absolutely. I mean, I couldn't agree more with you on this, Mike. And one of the areas that I've been thinking about recently, because it was a subject of a moot court presentation that I participated in at the ACI conference last week, is the scope of the internal controls provision. And I think there's an incredibly compelling case to be made that based on the text, that it is an accounting control provision, and yet you see the SEC resolving some of these employment cases as though the controls provision really was a compliance provision that is similar to what's in the UK Bribery Act or Sapin-Due in France. And at some point, you want to step back and say, we're talking about the development of the law here, and judges ought to have a voice in how the law is interpreted. I mean, that's how our process ought to work.
Yeah, you raise a good point about the books and records and internal control provisions. Granted, these are less sexy provisions than I think the anti-bribery provisions, but if you're looking at off-the-rails FCPA enforcement, I completely agree that there is a lot to be said as to the invalidity, I'll say, in terms of a lot of the SEC internal control theories. In terms of putting the DOJ to its burden of proof, you often hear, well, gee, it can't happen. It's just not good from a risk aversion standpoint to do that. And I'll come back to the example. Well, if FedEx can put the DOJ to its burden of proof in a criminal trial, which it recently did and won, why can't it happen in the FCPA context? There's this, I think, a myth, the so-called Arthur Andersen myth, that if you do that, you're going to go into a death spiral. When FedEx did it, and 10 minutes ago on my street, I just saw a FedEx truck. They're still delivering packages.
Yeah, well, they didn't make it to my block today. You're absolutely right, but at the end of the day, these are not questions that lawyers resolve. They're questions clients resolve, and I think it is often the case that lawyers arrogate to themselves too much responsibility for choices that ultimately are their clients. And in my consistent experience, what happens is that you go in and you talk to senior management and you talk to the board and you say, these are the range of possible outcomes, to the best of our ability. Here are the likelihoods of various outcomes and results, and based on our discussions with DOJ, here is the best compromise solution that is on the table, and then they pick. And they have consistently picked the settlement option, and I agree with you that we would all be a whole lot better off, and by all I include the DOJ, if more clients were to say, no, I think we're going to put the government to its proof.
No, you're absolutely right. I think there's a lot of FCPA lawyers that are probably chomping at the bit to expose some of these enforcement theories, but at the end of the day, this is essentially a business decision that is reserved to the business judgment of those running the company. I often wonder, though, and this is not so much a question as an observation, I often wonder, though, what type of information the board or the audit committee is getting in making this decision. Is there a balanced portrayal of the vulnerabilities of the DOJ's positions? All over and play dead mentality is the only option presented. Cooperate and settle.
I think there's certainly an element of that, and I have to say I think that there is probably a relative absence of any kind of enthusiasm generally in the defense bar to actually litigate things, and so I don't think in many cases that the boards are getting a balanced portrayal of the various risks, and I don't think the lawyers have a desire to engage, and I think it's helpful, and I think it's even helpful to be prepared to portray that in the context of resolution. I had one pretty significant case where the government was making a demand that I just thought was silly, and there was no way to compromise from the number that they were proposing to something that I thought that the client should live with, and basically said to the fraud section attorney across the table, I understand the strengths of your case. I understand your feeling about what happened here, but I think you need to reflect on what the trial is going to look like and who your witnesses are going to be, and some of the legal problems that you have in what is a fairly aggressive theory of jurisdiction. And why don't you just spend a couple of months thinking about how you're going to try this case, and my client will spend a couple of months thinking about what the risks are and whether they're going to embrace it. And at the end of that period, we came back and talked and started talking about a number that was about 25% of the last number that was on the table. And it was an incredibly healthy exercise, I think, on both sides.
Yeah, obviously that was lawyering, but that lawyering is done around conference room tables in D.C. with very little transparency and very little benefit to the rest of the other business community who may be subject to similar sort of aggressive enforcement theories. I'd like to return to an issue that you have unique expertise in. From my perspective, probably more expertise than other FCPA lawyers, given your representation of many foreign companies here. is, what is the proper law enforcement agency to actually, bring these actions? When you look at recent FCPA enforcement actions against foreign companies, we're talking about companies from Germany, from Switzerland, from France, from the Netherlands, from Canada, from Belgium. In other words, all OECD convention peer countries. And the OECD convention specifically says that when more than one party has jurisdiction, there's supposed to be a consultation to see which jurisdiction has the most appropriate means to bring that case. That's a long way of me teeing up the following question, and that is, can it truly be said that in many of these recent FCPA enforcement actions against foreign companies, that the United States was the most appropriate jurisdiction to prosecute these cases?
I think the answer to that is no, and but I also think that you have to look at this in a somewhat iterative sense, and my sense is that over the last 20 years since the OECD convention was adopted, the U.S. has taken an intentionally provocative role in terms of the assertion of its jurisdiction, with the expectation that the fairly aggressive positions that it has taken will catalyze indigenous enforcement efforts in the other OECD countries. And, it's been a frustrating experience as a defense lawyer to be on the other side of that, where in my view, the U.S. interest really was nominal, although, as you well know, jurisdiction's binary. I mean, it's on or it's off. But my sense is over time that part of the reason that we're seeing more aggressive prosecutions originating in England and Germany and because of their expectation and the signals that they've been getting from the DOJ, that if those folks step up and take a more vigorous role, the U.S. will step back.
Now, of course, when the U.S. lacks jurisdiction, that's not stepping back from a case. That is, legally speaking, a case that can't be brought. And to be sure...
No, but I guess I would put it another way, which is that the thing about jurisdiction, and that's the reason I say that it's binary, is that it either exists or it doesn't, but it is not a very useful measure of the strengths of the legitimate U.S. law enforcement interest. And that, to me, is a very different and very qualitative question. And I do see signs from DOJ that they are beginning to recognize that, and certainly my recent experience with Brascom and Odebrecht reflects the U.S. in its cooperative role in that case with the Swiss and the Brazilians, making an assessment of what is the strength of their interest, in addition to whether or not they simply have jurisdiction, and adopting a role that's really consistent with the strength of their qualitative interest as opposed to merely the strength of their jurisdictional argument.
Yeah, and I think there might be some, movement in this space, as you mentioned, and we are seeing with increasing frequency U.S. law enforcement agencies crediting settlement amounts in foreign jurisdictions. But, the fact remains that in 2016, 40% of FCPA enforcement actions were against foreign companies. And from a settlement amount perspective, approximately 65% of FCPA settlement amounts, came from foreign company resolutions. And again, all of these companies were domiciled in OECD convention, peer countries. Going forward, would you like to see, from a policy standpoint, the U.S. just to not credit, but just to completely back off of those prosecutions, recognizing that, well, there's another more appropriate law enforcement agency that can handle this?
Well, I guess I would suggest another way of looking at that altogether, which is something I kind of urged with only limited success in the SBM context, which is that the U.S. has taken a pretty clear position that they're going to credit amounts paid to other jurisdictions. But the problem with that is that it doesn't measure the strength or quality of the U.S. law enforcement interest. So what happens is that you do a fairly arithmetic exercise, which is DOJ decides what the guideline range is for a potential resolution of the underlying conduct. And then it subtracts amounts paid to other jurisdictions, and then they say, well, even taking account of cooperation and other factors, this is the U.S. fine. It's $10. You've paid $5 to the Brazilians. You owe us $5, without regard for whether or not the conduct was really had a strong nexus to the United States or a weak nexus to the United States. So, for example, a conspiracy which is born and bred and managed and fed from New York City is treated exactly the same way as a conspiracy that is born and bred and managed and supervised from Paris, but happens to have one employee based in the United States or a handful of wire transfers in dollars. And from the U.S. perspective, they rather mechanically say, well, the right fine is the same in both of those cases. And I fundamentally disagree with that approach. I mean, I think there needs to be some recognition in these multi-jurisdictional cases about what the qualitative strength is of the U.S. interest before you start just, subtracting.
Well, that's an excellent point. I'd like to close by asking you a big picture question. As the FCPA soon approaches 40, do you believe that the FCPA has been successful in achieving its objectives, recognizing that success can mean a number of different things? And then related to that, if you were FCPA King of the Day, what changes to the FCPA, either the actual statute or perhaps enforcement agency policy or guidance, would you make and why?
Well, as to the former, I certainly have seen over the last 15 years representing foreign corporations remarkable evolution in terms of their conduct abroad. And I think a great deal of that credit goes to enforcement activities by the DOJ. For some of the matters where I've been representing French companies, the conduct began in the 90s when it was still lawful, not only lawful in France, but where companies could go in on a case-by-case basis to the tax authorities and obtain permission to deduct bribe payments that were made off the books as ordinary business expenses. And what you now see across Western Europe is a sincere and committed effort at compliance worldwide. And it's hard not to look at that and not to conclude that the world is a somewhat better and more honest place as a result of that. At the same time, I think to answer your second question, if I were FCPA King of the Day, I think I would be less interested in specific statutory changes and would urge the department to transition from being the world's cop to being part of what is a truly multilateral and worldwide enforcement structure. And I think that is the challenge for the next 10 years. I mean, it's easy to sit here and say, well, these things need to be multilateral and they need to be joined and there needs to be deference. But you've got different penalty structures, you've got different legal systems, you've got different rules regarding Fifth Amendment privileges and double jeopardy. And so I think we're going to be living in an incredibly exciting period where you are going to have to integrate diverse legal systems without overarching norms and forms of agreement. And that's going to be an incredible challenge for everybody.
And from a practice standpoint, that just demonstrates how the skill set of an FCPA lawyer is not static, but needs to be changing. And today's guest has obviously demonstrated that by his many representations of foreign companies in the FCPA context where a lot of these issues arise. So thank you, Bob, for being a guest on the podcast and talking about the issues that we talked about.
Well, thank you. I'm delighted to have a chance to participate, Mike.